Good morning, everyone.
Good morning.
Doug, how's the sound
Morning.
quality?
Sound is very good.
Okay. I see that there's one person on the phone. Did you want to do a sound check? Okay, I don't know who's on the phone.
It looks like that person may be on mute. There we go.
This is Steve Tolson. Can you hear me now?
Yes, I can.
I'm
Doug's-
sorry. I hit *6 to unmute. I was just saying, Your Honor, it's Steve Tolson representing PPRP. I'm at my office in Baltimore. My desktop computer has neither a microphone nor a camera, so I'm using my antiquated iPhone to appear via telephone.
Okay, that's fine. I noted when you came on, I think there was some feedback, so I just wanted to do a sound check to make sure we were good.
Yeah, I was trying to have my cake and eat it too by pulling up the screen, and I realized that created feedback, so I had to exit the meeting online and just use the phone alone.
Okay. Again, good morning to everyone. Welcome to the Public Service Commission's evidentiary hearing in case number 9635, which is captioned in the matter of the application of Newmarket Solar LLC for a certificate of public convenience and necessity to construct a 50 megawatt solar photovoltaic generating facility in Dorchester County, Maryland. We will start with appearances, starting with the applicant, please.
Good morning, Your Honor. David Buglemans on behalf of the applicant, Newmarket Solar LLC.
And PPRP.
Good morning, Your Honor. Assistant Attorney General Steve Tolson on behalf of the Department of Natural Resources Power Plant Research Program.
Staff.
Good morning, Your Honor and parties. This is Kenny Albert on behalf of Commission staff.
And OPC.
Morning, Your Honor. Frederick Hoover on behalf of the Office of People's Counsel.
Okay, thank you. Mr. Buglemans, I believe you're going to want to enter some exhibits into evidence. And I don't know if you double checked. I did. You'd be starting with exhibit 3.
That's correct, Your Honor.
Your Honor, are we on the record now?
Oh, I'm sorry. Yeah, Doug, we're on the record. Sorry, go ahead, Mr. Buglemans.
That is correct, Your Honor. We would start at exhibit 3. There are no disputed issues in this case, although I understand you have questions. But what I would recommend is we could go through all of our exhibits, including testimony, move them into evidence, and then after that, we can make the witnesses available to answer your questions.
That's fine. I didn't know if, because my questions might cause parties to have questions, even though they've probably, don't plan on having any cross-examination. If my questions lead to questions, I didn't know if you should perhaps do the voir dire of your witnesses to the extent of, affirming their testimony.
I don't think it's necessary. I think we can all stipulate to the testimony, and the witnesses can be available for questions. If Your Honor would like me to, I'm happy to do it. I don't know procedurally if we have to.
If you don't think it's necessary, we can proceed and enter the testimony by stipulation then.
Okay, thank you, Your Honor. Okay, so I'll run through the list. The first new exhibit today, Your Honor, is applicant exhibit 3, which is the CPCN petition that was filed on February 14, 2020, consisting of 9 pages under mail log number 228599.
The petition will be marked as applicant exhibit 3.
Thank you, Your Honor. Next up is applicant exhibit 4. We have the environmental review document and appendices, also filed on February 14th, 2020, 390 pages. And that was also under mail log number 228599.
Okay, the environmental review document with appendices will be marked as applicant exhibit 4.
Thank you, Your Honor. Next is applicant exhibit 5. I would like marked the General Assembly and Local Government Notices Compliance filing, which was filed on February 26, 2020, consisting of 5 pages under mail log number 228807.
That was already entered into the record as applicant exhibit 1 at the pre-trial.
I do see that. I'm sorry, Your Honor. Yep, I missed that. Okay. All right. So we'll skip that and make applicant exhibit 5, the, sorry here, make sure I get this right. As applicant exhibit 5, we will do what I'm calling an additional notices compliance filing, which is filed on April 22nd, 2020. It consists of 55 pages under mail log number 229858.
That'll be marked as applicant exhibit 5.
Thank you, Your Honor. Next up, we have the compliance filing for the first public comment hearing that was filed on June 3rd, 2020, consisting of 5 pages under mail log number 230555.
That'll be marked as applicant exhibit 6.
Thank you, Your Honor. Next, as applicant exhibit 7, we have the direct testimony of Lyndon Adike, filed on June 19th, 2020, consisting of 11 pages under mail log number 230803.
That'll be marked as applicant exhibit 7.
Thank you, Your Honor. Next is applicant exhibit 8. We have the direct testimony of Dane Bauer, also filed on June 19th, 2020, consisting of 4 pages under mail log number 230803.
That'll be marked as applicant exhibit 8. Did he have any attachments? No.
He did. Well, he had his resume, Your Honor, but and that's included within the page count, I believe.
Okay, thanks.
Thank you, Your Honor. Next is applicant exhibit 9. We have the supplemental direct testimony of Ryan D. Showalter that was filed on August 13th, 2021. Mr. Showalter's testimony, including attachments A and B, consists of 452 pages, and that was filed under mail log number 236601.
Okay, that'll be marked as applicant exhibit 9.
Thank you, Your Honor. Next, we have as applicant exhibit 10, the supplemental direct testimony of Lyndon Adike, also filed on August 13th, 2021, consisting of 9 pages under mail log number 236601.
Okay, that'll be marked as applicant exhibit 10.
Thank you, Your Honor. Next, we have the supplemental direct testimony of William R. McCain. This was also filed on August 13th, 2021, but I would like to note that on the docket, it's showing as filed on August 16th. I think what happened was this came down to the wire. We pressed submit slightly after 5 p.m. I don't think any parties have raised objections. To the extent it's considered late, I think it's not going to prejudice any party to admit it, but I haven't moved anything into evidence yet, but I wanted to raise that at this point.
Okay, noted.
Okay.
That'll be marked as applicant exhibit 11.
Thank you, Your Honor. And that consists of 9 pages for the record. Next is applicant exhibit 12. We have the settlement status update that was filed on November 19th, 2021. That's 1 page under mail log number 237915.
Okay, that'll be marked as applicant exhibit 12.
Thank you. And then last but not least, we have the second public comment hearing notice compliance filing filed on November 29th, 2021, consisting of 6 pages under mail log number 237981.
That'll be marked as applicant exhibit 13.
Thank you, Your Honor. And with that, I would request to move applicant exhibits 3 through 13 into evidence.
Any objection? Okay, hearing and seeing none, applicant exhibits 3 through 13 are entered into the record.
Thank you.
Okay, since we're not going to order any witnesses, why don't we go ahead and get all of the exhibits in and then we'll circle back. Does that work for you?
Sure.
Okay, so PPRP. Sorry, Mr. Towson, I muted you. You have to unmute yourself because.
Okay, I'm sorry, Your Honor. I'm unmuted now, I believe. Can you hear me?
Yes.
Oh, thank you. PPRP has 10 exhibits that were entered on November 17th, 2021 under mail log number 237872. I'd like to have them marked and then I'll move for admission. PPRP exhibit number 1 is the filing letter represented by counsel. PPRP exhibit number 2 is the state's secretarial letter. PPRP exhibit number 3 are the recommended licensing conditions for the CPCN. PPRP Exhibit 4 is the direct testimony of Ginny Rogers, who is the project manager for PPRP on this particular case. PPRP Exhibit number 5 is the project assessment report. PPRP Exhibit number 6 is Appendix A to the project assessment report. It's in 3 parts, so this is part 1 of 3. PPRP Exhibit number 7 is the Appendix A, part 2 of 3, and PPRP Exhibit 8 is Appendix A, part 3 of 3 to the PAR. PPRP Exhibit number 9 is Appendix B to the project assessment report, and PPRP Exhibit number 10 is Appendix C to the project assessment report. And so with those 10 exhibits identified, I would like to move for their admission into the record at this time.
Okay, you threw me with one. You want the cover letter entered as Exhibit 1?
We don't always do that, Your Honor, but you know, there is a requirement that parties be represented by counsel. That shows that they're represented by counsel.
Okay.
I'm agnostic.
If no one has an objection, I don't have an objection. I just wasn't used to that. Okay, so
Okay.
PPRP exhibits 1 through 10 are marked for identification, and then did you move them in?
I requested that they be moved into admission if there's no objection, Your Honor.
Any objection? Seeing and hearing no objection, PPRP exhibits 1 through 10 are entered into the record.
Thank you, Your Honor.
Thank you.
May I also add, online today with me is Ginny Rogers, the project manager, who will be available for any questions you may have. And I can do an attestation if you would like later on.
Yes, I'll have you do that later. Thank you.
Thank you, Your Honor.
Okay, staff, Mr. Albert.
Yes, Your Honor. We have a staff. We would like to mark as staff exhibit number 1, the original version of the direct testimony of staff witness Andre Wilson.
So marked.
DeAndre Wilson, which was filed on November 17th in mail log 237867.
So marked.
We would like to mark as staff exhibit number 2, the revised direct testimony filed by staff on November 19th, 2021 in mail log 237915. We have 2 versions as a clean, so perhaps the staff exhibit number 2 could be the clean version, and staff exhibit number 3 would be the red line version of that revised testimony.
Okay, that's fine, except I think you misstated the mail log number. I have it as 237957.
Yeah, I'm sorry. I was referring to the earlier filing by the project that indicated that the specific contracts they needed for PJM, which was what drove Mr. Wilson to file his revised testimony. So you're correct. I missed up those. Yes, it is 237957 for staff's revised testimony.
Okay, so staff exhibits 1, 2, and 3 are marked for identification.
And we would then ask that those 3 exhibits be introduced into the record.
Any objection?
No objection.
Okay. Hearing and seeing no objection, staff exhibits 1, 2, and 3 are entered into the record.
And that's all staff has for the record.
Okay, thank you. I first had a question for Mr. Bauer. Well, and I'm not going to promise that it's only one, but I did have some questions for Mr. Bauer. If you could provide me, Mr. Bugelmans, with an attestation, I would appreciate it.
Sure. I hereby attest that Mr. Bauer is alone in a separate room and not in communication with any other individual.
Okay, Mr. Bauer, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth? You're on mute. Can you unmute yourself?
I do.
Okay. PPRP noted that the project's operation will not generate any hazardous waste that could potentially affect public health, and that at the end of the facility's useful life, a decommissioning plan will ensure all components are dismantled and removed. And license condition 37, which is solar decommissioning, does provide for a plan to be filed that will describe the responsible parties, timeframes, and estimated costs for decommissioning, dismantling, and legal disposal of all components. But those were the only mentions of waste disposal that I saw. I understand that this is a solar facility, but typically in an ERD, there is a statement regarding the disposal of waste materials produced during construction, and I didn't see that. Or a reference to disposal of waste during commissioning, not in the ERD. I don't know if you can point me to it, or you can just tell me the applicant's plans for waste disposal.
I don't recall whether we addressed it in the ERD or not, to be honest with you, but based on my experience with these projects and from, running an engineering firm that did a lot of construction, the only waste material that you could not possibly, that you may even consider would be all of the equipment that's used on site and the oils and petroleum products and whatnot that could leak. And to my knowledge, almost all of those firms have a plan to address those things within a timely manner should they get an unlikely spill. And they put it into effect, and there's usually another crew that comes out and cleans it up, contains it, and reports it to the state.
There is a spill license condition. I guess I was referring more to really at a very basic level, any materials that are used for the installation of the panels that might get left behind or anything like that.
I don't know anything that would be considered hazardous that has to do with the installation of the posts, the brackets, or the trenching in of the electric or fitting the inverters in place.
I'm not limiting my question to hazardous. I know I don't expect you to necessarily be familiar with the code, but I need to consider under the code the waste and waste disposal. It's not hazardous. I noted that PPRB talked about the lack of hazardous waste, but I'm not limiting my question to hazardous waste. So, there's some installation required, right, of the panels on the site, and the construction workers, might have some materials associated with that installation. And I think it's a pretty, like I said, a basic question of if there's any materials that are left behind. Do you know if there's a condition that would address that, or if the applicant has a plan to ensure there isn't waste left on the site?
You might want to readdress that to the applicant, because I believe the standard contracts that they have with the EPC requires them to police the site and to eliminate all rubble or materials or pieces of metal or clipped wire that are on site. That's my general knowledge, but I think she would know more specifically.
When you say she, do you mean witness Nowadiki?
Yes.
Okay, I
Your
can ask
Honor.
her. I can ask her then. Have you reviewed the comments that were submitted by the Director of Planning for Dorchester County?
I don't believe I have seen that. Do you mean the ones that were related to the setbacks?
Yes.
I did see those.
Okay.
Yes.
Well, two things were submitted. One was a statement from, I believe, the county council, and then attached to that or accompanying that was a document entitled Landscape Requirements. Is that what you're referring to that you've
Yes,
reviewed?
I did read that.
Okay. Did you compare those landscape requirements in that comment to what the applicant proposed?
Yes, I did.
You did. Okay. Can you tell me where the applicant's plan would conform to those landscape requirements?
Well, in general, we had proposed in the ERD and on the plans 3 different types of buffer screening. All of them had to do with degrees, the amount of vegetation, how dense it would be, whether or not each one of those areas would incorporate existing trees and then we were just enhancing it, or whether or not we were adding vegetation, 100% vegetation within 50-foot buffers. So all of those setback buffers were 50 feet to be consistent with the existing code, the county code. The comments related to a proposal at the county that has not been adopted, it's being considered. And it would change the setbacks from 50 feet to 200 feet. I did ask the civil engineer on the project, Davis, Bowen, and Friedel, the principal there, Jason Lohr, to give us an approximation of how many acres of additional area would be required. So in addition to the 50 feet, we'd have to add another 150 feet. He told us with a very quick and dirty assessment that it would add another 60 to 65 acres of land that would have to be committed for and dedicated to that purpose alone. He was not able to take it further and to define to what extent it may affect the capacity of the system. But he did say that it would likely reduce the limit of disturbance in some areas, and he didn't know to what degree it would be because he didn't have time to finish that part of the assessment.
Okay, but you're saying that, and I do understand that they are, I guess, what's being considered and hasn't been enacted yet. But the plan, the latest plan that the applicant has put forth still has 50-foot setbacks. And so it wouldn't conform to the setback requirement of 200 feet minimum.
If it became code, I can't say that it would or would not.
No, I don't mean, okay, let me be more clear. The plan provides for 50-foot setbacks, and that wasn't increased beyond 50 feet as of now.
Yes, that is correct.
Okay.
We designed the system to meet the current county code.
I thought there was an indication that at some point the applicant revised the site plan. I think it was in October, early October, there was a revised site plan, and I didn't know if there were increased setbacks or anything that changed from the original.
That had to do with proximity to the closest homes. So we did add 130 feet in one location in order to achieve a 250-foot setback from the fence of the project to the front property line of the residence in question, which gave us a 250-foot setback. We also did the same in another direction in order to achieve 1,276-foot setback from the closest residence in the town limit in East Newmarket. And that again would be measured from the fence of the project to the property line of the closest house in question.
Okay. I don't know what the current code provides for. This document that was submitted as a comment provides that setbacks shall be measured from the nearest solar panel / structure within the solar array, excluding security fence screening. And then it has a setback of 500 feet minimum from nearest residence exterior wall. Do you know, or does witness Nowotny know whether that measurement has been conducted or obtained?
We haven't been, directed to take that step to make that determination. So
Okay. And you don't know then the distance from the nearest residence exterior wall to the nearest solar panel?
well, I can tell. No, I don't. But I can tell you that the 250 foot that we measured to the closest house in town was from the fence to the property line. So the house is definitely sitting back some distance off the property line. So we're further than 250 feet to the building itself. How many feet, I cannot tell you at this point.
Okay, what about the, I'm still in that document that's entitled Landscape Requirements that was submitted as a comment. 5, landscape plan. Did you review that portion?
Yes.
Okay, do you know if there's any portion of that that the current applicant's plan wouldn't be in compliance with?
I think it would be, all I can tell you is it would be in compliance in some areas and may not be in others. And I think Ryan Showalter, who's another one of our witnesses, has more details about how the local code conforms with the current project design.
Do you know how high the fence is?
The fence is 6 feet high with a 1 foot on top of that of barbed wire.
Okay, so it wouldn't be in compliance with the fence provision Romanet 2 where barbed wire is prohibited. Okay. Do you know if the, and I can wait and ask Mr. Showalter, if the maintenance agreement in paragraph J is different from the maintenance agreement that the applicant provided for?
I think Ryan would be the better one to address that.
Okay. Okay. Then I will talk to him. Mr. Bugelmans, would you please give me an attestation for Mr. Showalter?
Sure, Your Honor. I hereby attest that Mr. Showalter is alone in a separate room and not in communication with any other individual.
Thanks. Mr. Showalter, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
Do.
Okay, so you're aware of how the land on which the project is proposed to be constructed is zoned, correct?
Yes, Your Honor.
And that would be, what's that zoning?
I'm sorry, let me just go back to my notes. It's I believe it's AC, but let me just confirm. I'm sorry. Yes, it's the county's agricultural conservation district. AC is the abbreviation.
Okay. And as I understand your testimony, your opinion is that the application is consistent with that agricultural conservation zoning because the applicant's special use application was complete. Is that, do I have that right?
Well, not only because the application was complete, but also the substance of the application complied with all of the substantive standards established under the supplemental use standards of the zoning district for this use.
Okay.
So it was complete, but also compliant.
Okay. If we back up, my understanding is that in general, uses can be permitted, prohibited, or allowed by special exception. Do I have that right?
That's the general structure under Maryland law. That's correct.
Okay. And if a use is permitted in a particular zoning, would you say that that use was consistent with the zoning classification?
Yes,
And if a use is prohibited in a certain zoning, would you say that that use was inconsistent with the zoning?
yes.
So with the in-between option of a use that is allowed by special exception, before we get to your testimony and whether an application is complete and substantively has compliant, before we get to that point, I just want to understand how you would describe a use that is allowable by special exception. Is it consistent, inconsistent, neither, both, not inconsistent? One of those options.
I would say it is consistent, Your Honor. And if you look at the Maryland case law, what the courts have consistently held is that a use that is permitted by special exception is presumptively valid. So when the county council adopts the zoning ordinance, they can elect between those three general approaches: permitted by right, not permitted, or the hybrid approach. And the adoption of a use table that designates solar as a use permitted by special exception creates a rebuttable presumption that the use is permitted. And the county council created that presumption legislatively by adoption of the zoning ordinance. And that presumption is rebuttable by opponents to a project if they present specific information that demonstrates that the use will have impacts at this particular location that are different than impacts that are inherent in the use in general. So there are certain impacts associated with the development of solar, and those may be aesthetic, they may be landscape changes. Those impacts are inherent in solar regardless of its location. And by the county council's adoption of the zoning ordinance and designating it as a special exception use, those impacts were legislatively accepted by making it permitted. Yeah, and when the applicant submits an application, the applicant basically is entitled to that rebuttable presumption, and the opponents to a project can present project-specific reasons why the presumption might be overcome. But if that doesn't happen, the special exception should be granted. And so in this case, the applicant submitted an application that is complete, that complies with the substantive standards established in the ordinance for solar, and therefore is consistent with the ordinance and presumptively valid.
So, but if we're still working under my hypothetical and an applicant, not this applicant in particular, just an applicant files a special use application that is not in compliance and not complete, you would still say the use would be consistent with the zoning?
Yeah, so I think there's two. The use in general is consistent with the zoning. The use has to be developed in a manner that complies with substantive standards by the county, but the
Okay,
use is
so
permitted subject to those criteria.
okay, so following the hypothetical, if an applicant files a application for special exception and it is contested or opposed by various people and they rebut the presumption, you would still say the use was consistent.
That's correct.
Okay, so do you have your direct testimony in front of you?
Yes, Your Honor.
At page 10, starting on line 5, with regard to the solar component of the project, you testified that the proposed use will be consistent with the county comprehensive plan, in part because the comprehensive plan is intended to enhance the quality of life and protect the rural character of Dorchester County while protecting residents' health, safety, and welfare. And attachment A to your testimony that's been entered into the record is the 1996 comprehensive plan. It's a 222-page PDF Can you point me to where that language is in that document?
Your Honor, I do not have the complete copy of the comprehensive plan, but I can pull it up during this hearing and provide you with that reference.
Okay, because at least the copy I have, it's not searchable, so I couldn't find that language, and you didn't have a cite to it.
Okay.
And
I can also
then,
forward a copy to the witness, although I'm sure probably has a copy somewhere on his computer, but
okay, I don't know how quickly he can find it in the document, but you're welcome to do that, sure. Then you pointed me to chapter 3 of the document. If I get there. That starts at page 61 of the 222-page PDF. You said that chapter 3 of the plan calls for the county to provide a strategic effort to create a more diversified economic base for the county. In particular, the plan recommends that the county undertake efforts to retain or expand existing businesses and to market the region as a premier location for innovative businesses. Were you referring to page 3-3? I believe.
Yes, Your Honor. 3-3 is the economic development subsection of that chapter 3.
Okay, I see the language. Through its Economic Development Office, Dorchester County has embarked on a strategic planning effort to create a more diversified economic base for the county, which I think is where you got that language. But then it goes on to say the key components of that planning effort are to identify industry growth opportunities and to recommend strategies to respond to the loss of defense industry related jobs. So I guess I'm not understanding where you get the I guess I need you to point me to the plan recommends that the county undertake efforts to retain or expand existing businesses and to market the region as a premier location for innovative businesses.
Just a second. Sorry, I'm looking at it on my phone while I'm doing this. So
Oh, that's probably worse than.
It's a little small, but so, Your Honor, I guess the term innovative businesses may not be, the term innovative may not be in there. If you look at that paragraph, they refer to, and remember this comprehensive plan was written in 1996, but refer to industries that are intended to be attracted. Those include aquaculture, including healthcare services and recycling. So I guess I would say that my use of the word innovative is more of a paraphrase of their goal to look towards more progressive businesses. I don't know that the word innovative appears in this paragraph.
Okay. Because then you go on to say that the project is of the kind that enhances the county's image as forward-thinking and innovative, and demonstrates the county's sincere efforts to protect the environment and natural features that make the county unique. And I wasn't able to find language to support your testimony that the project is of the kind that enhances the county's image as forward-thinking and innovative. And I know it was written in 1996, but it's your testimony based on it. So if there's anywhere else you can point me.
So when you look at, give me just a second. The county image section, page 3-5, down through 3-6, highlights the county's concern about its lack of positive image and identifies a number of challenges with the county's image, perception with respect to the business environment, lack of can-do attitude, rundown areas. And so the plan overall presents a desire to increase the image, to provide streamlining of their regulatory approach, to find ways to market the county and enhance its image to counteract its negative publicity. As a plan, a comprehensive plan as a whole is a vision. So the vision that I would say is articulated by this economic development chapter is a desire to see support for industry in the county that enhances the image of the county while still maintaining the the rural nature of the county, protecting the county's environment. Green renewable energy is certainly aligned with the image that the county is intending to or desired at that time to create. It does provide some economic investment and opportunity, and it's different than the defense industry and the sort of the general assembly and food products industries that the county was struggling with and still struggles with, frankly.
Okay. I mean, I see references in that goal of industry to jobs, more so than what you might be indicating comes from a solar facility.
Well, certainly there will be jobs associated with the construction, but the economic benefits to the county, the tax benefits to the county, in this case, are very substantial, but avoid the externalities associated with other types of industrial activity. You don't have traffic, you don't have demands for public services, but you do generate significant tax revenue. In my mind, that is consistent with the county's goal of diversifying the county's economic activity, increasing the county's industrial tax base.
Okay, so then I'm still on your testimony. You went on to say that the plan indicates that non-residential land uses may be compatible with agricultural area goals provided site development performance standards are met, and recommends that to the extent the county desires to encourage non-residential land uses in agricultural areas, it should consider amending its zoning ordinance to incorporate floating zones and/or zones with a site plan with performance standards to address visual impacts on Dorchester's flat landscape.
Right.
I guess, first of all, do you know where that is in the plan? That language?
I will find that while we're working here. I believe it's in the land use chapter, but let me find that. If you want to move to your next question while I'm looking, happy to address that.
Okay, well, do you know did Dorchester County amend its zoning ordinance in pursuant to this recommendation? That's somewhere on the plan.
Well, so one, specific to this application,
No. We talked about how this plan was adopted in 1996. And
Right.
assuming that this recommendation is somewhere in here, it seemed to be suggesting that it happened. I'm kind of talking about in general. Did it happen sometime after 1996?
Yes.
Okay.
And specifically relevant to this application, the county adopted, subsequent to 96, adopted the solar specific standards that are in section 155-50, the supplemental use standards.
Do you know when it adopted those?
I need to confirm. I believe they were adopted in 2014, but I will see if I can find that for you in just a second.
I have you looking for multiple things. I'm sorry.
You do.
Do you need a minute?
No, I'm going to just make notes of what I need to find for you.
Okay. All right. So the phrase they have incorporate floating zones and or zoning with a site plan. Do you know what the phrase zoning with a site plan refers to?
So the county from probably 2000, well, prior to the 2010 range, 1990s, early 2000s, permitted more uses without site plan approval. The uses that were permitted by right generally required a building permit. So the current county code structure requires site plan approval for many more uses, certainly for solar, which means that in addition to having the need to get a construction permit, the application first is reviewed by the Planning Commission with a site plan where they have the opportunity to review matters such as access and landscaping.
Okay. And then with performance standards, the phrase performance standards, not familiar with that phrase.
So that phrase refers to qualitative standards for design. In the past, the county really just had categories of uses and bulk standards, which are, building height, lot area, setbacks, dimensional or numerical standards. Performance standards are standards that are more subjective and address the quality of the design. So relevant to this application, the standards in section 155-50 that I would characterize as performance standards are those that address things like lighting, the requirement that wiring be installed underground, the requirement for 50 feet of vegetative screening from views of existing residences. Those are performance standards instead of, or in contrast to bulk standards or numerical standards.
Okay, then you went on to testify that Dorchester County has implemented the vision outlined in its plan by authorizing utility scale solar farms in the AC district by special exception and site plan review subject to visual screening standards. Such projects must meet the lot size, height, planting, and other requirements of Dorchester County Code 155-50. But then you indicated that Dorchester County is in the process of updating its comprehensive plan, and you attached to your testimony, and it's been entered into the record as attachment B, a draft. I believe it was as of August 2021. Does that sound right?
That's right.
Okay. Oh, actually, I'm sorry. I pulled it up. It says July on the first page. According to PPRP witness Rogers, Dorchester County adopted a new plan on October 19, 2021. Have you reviewed that?
I have.
Do you know, is it publicly available?
Last I checked, Your Honor, it was not. They were waiting on the last county council member to sign it, and that was approximately 9 days. It was right around the first of the year. I checked this morning. It's not yet on the county's website.
Okay.
It is a public document, under the Maryland Public Information Act, but it's not yet readily accessible to the public.
And then I tried to pull up what is available on the website, which I guess is the same thing as yours, but I can't. So I can't confirm that it's yours. It does have that same July 2021 date, though. Just so you know, I'm looking at the Dorchester County, Maryland.com website.
Right.
Talks about the comprehensive plan update. It says current draft. Click here, Dorchester County Comprehensive Plan - July 2021. But if you click on it, at least I'm not able to pull it up. Okay, so you said you have it. The one that was adopted in October of this year.
Yes, Your Honor.
Okay.
Okay.
Go ahead.
It is, there were a few minor changes to exhibits or illustrations in there, not relevant to the solar chapter, but it is substantially identical to the August version that was filed with my testimony.
Okay, that's helpful. That was one of my questions. But Mr. Bugemans, do you object to him producing this document to complete the record in this case?
I would not object, Your Honor.
Okay. What I'd like you to do then, Mr. Showalter, is send it to Mr. Bugemans if he doesn't have it, and then he will forward it to everyone. Depending on what PPRP tells me with regard to its conditions, the record will likely close today. So if you can get that to us today, that'd be great. But I'll hold the record open to add that to the record. We'll call that bench 1.
Is that something, Your Honor, I could file that in the docket, or I could just circulate it via email? I just want to make sure I do it appropriately.
If you want to file it,
Okay.
that would probably be, the most official and
Okay, we'll do.
great. Then I don't have to get it somewhere either. It might be pretty lengthy, so yeah. Okay. So you said it's substantively the same, though, as the draft attached to your testimony that you did discuss. So does it still not impose specific standards, but continues to recommend amending the zoning ordinance and or passing legislation specific to solar installations?
That's correct, Your Honor. A comprehensive plan articulates a vision and does not itself impose standards or regulations. So it articulates a vision. In my opinion, the vision it articulates is a desire not to see any additional utility scale solar in Dorchester County.
Yeah, no, we'll get there. We'll get there.
Okay.
Does it still have language about protecting residents' health, safety, and welfare?
It does.
Okay. And according to your testimony on page 22, the new plan specifies that Dorchester County generally supports renewable energy sources to lessen dependence on fossil fuels or to reduce energy costs. And you gave me a site for that. It was at the Plan 1-8. So we have that. Okay. And the new plan also states that the county should develop requirements and approval processes that would guide solar farms to appropriate places and minimize potential visual noise impacts to surrounding uses, such as perimeter landscaped screening and buffers. And that's in that same paragraph. Okay. Okay, so then farther down, though, on your testimony on page 22, you indicate that the draft, what was a draft per your testimony, but is now an adopted comprehensive plan, includes provisions that may not be consistent with the proposed project. And on page 23, you indicate those would be the following areas: amending the zoning ordinance and or passing legislation that sets an aggregate acreage cap on the amount of land converted from forest or agricultural to solar installations, amending the zoning ordinance to establish a limit on the overall size of solar installations, amending the zoning ordinance to require solar installations to preserve a majority of prime farmland soils on parcels subject to the installation and prohibit development of the preserved lands for the life of the solar installation. And amending the zoning ordinance to require setbacks and buffers from roads and residential zoning districts. And I think there were some more. But as you said, that to your knowledge, the county has not yet made any of those amendments to the zoning ordinance?
The county has not made any amendments to the zoning ordinance. The only drafts that have been distributed or released to the public or discussed in public are the landscape requirements, the 3-page landscape requirements that Mr. Hammond, the county planner, provided to your honor last week, I guess it was. There have been discussions in a public session among planning commission members where individual members have articulated preferences to see a 50-acre cap per project established, and other substantive concepts have been discussed, but they have not been, to my knowledge, they've not been memorialized by staff in the form of a draft or any document that's available to the public or circulated.
And similarly, no other legislation, right?
No, there is no legislation pending to implement any of this.
Okay. So at the top of page 24 of your testimony, while the county has not yet adopted the plan at the time of your testimony, but now it has, the new plan appears to articulate an intent to severely restrict future development of solar projects in Dorchester County. And now that you've reviewed the plan as adopted, would you say that it articulates an intent to severely restrict future development of solar projects?
I would say that it does, Your Honor.
Based on the items we just discussed?
That's correct.
Okay.
And based also, so largely based on the items we discussed, but the plan was adopted in the context of a lot of discussion between the Planning Commission and Board of Appeals. And in that discussion, there was certainly information about the concept of preemption and what other counties have done. Chris Drummond is an attorney who represents other counties. He represents Queen Anne's County. He represents the Dorchester County Planning Commission. He also represents community interest groups opposed to solar. And so there's been a lot of discussion guided largely by Mr. Drummond for the benefit of the Planning Commission and the county's planning consultant about the county's potential role with respect to solar and how their regulations may be viewed. In the context of those discussions, the Planning Commission members seem very focused on keeping footprint, total footprint, landscape area and panels to something less than 100 acres. A number of 50 acres has been discussed. That didn't make it into the final draft of the comprehensive plan, but certainly the context of those discussions are focused on a scale and size that would not be consistent with anything other than community solar.
And when you talk about these discussions, you've mentioned them several times. Those are occurring in public contexts, public hearings?
Not public hearings, but they're public meetings. So those are probably half of them occurred in joint work sessions between the Planning Commission and the Board of Appeals. The rest of them occurred during regularly held monthly Planning Commission meetings. So they all occurred in public. They were listed on the agenda as comp plan or zoning discussions, but they've not yet held an advertised hearing to receive public comment on those.
Okay, and minutes of those meetings are available to the public? That's
certainly minutes of the Planning Commission meeting are available. I don't know whether they maintained minutes of their work sessions. I assume they did, but I don't.
You attended the ones you're speaking of, though?
I attended about half of them. The others I participated. They had conference calls available, so I participated remotely through their conference line.
So, Mr. Bauer punted to you, and I'm not sure that I don't know, maybe you're the right person. I guess the landscape requirements that were submitted as a comment that you have, what I wanted to try and figure out was in what ways the applicant's plan differed from those. Because you mentioned in your testimony ways in which the plan would not conform, I guess, to the applicant's site plan would not conform to the new draft comprehensive plan. Are you prepared to do that?
I am prepared to, I think probably most of it, Your Honor. I don't have the landscape plan in front of me, but these are not yet county requirements. These are proposals.
Oh, I understand. I understand.
And frankly, there are a number of them that I've worked on solar projects all over the state. I'm familiar with projects ranging from small scale 2-acre projects to 200 megawatt projects, and these in many cases these are requirements that exceed all industry standards and any requirement I've seen in any other jurisdiction. And a number of them, some that I'll highlight are just simply illogical.
Well,
One,
before you do that, what's the recourse?
what is the recourse?
Yes. Say Dorchester County did adopt these landscape requirements that were submitted as a comment in their form, which you're going to tell me contain things that are illogical. What would be the recourse for someone such as the applicant?
Well, Your Honor, the state law provides Public Service Commission with ultimate authority for these projects.
Okay,
And,
I'm sorry, not this applicant. Hypothetical.
okay,
Someone else comes along right after these are adopted.
right.
Doesn't believe that these are logical, to use your phrase, or some of them aren't logical. What's their recourse?
I think it depends on the nature of their project. If their project is under 2 megawatts and doesn't fall within the CPCN framework, I'm not sure that they have recourse. In the case of a project subject to the commission's review, I think the recourse is state level review to provide appropriate screening that can be implemented in a way that is effective. And I think that's the recourse for larger scale projects.
Okay, but now we have this applicant, and have you reviewed the license conditions?
Yes, Your Honor. I don't have those in front of me, but I did review those conditions.
Okay. Well, if you reviewed them, do you recall that there is one in particular that requires the applicant to certify to the Public Service Commission by filing a statement in the docket that it has designed the facility in substantial conformity to Dorchester County site plan requirements, including a landscaping plan? Are you
And I'm
familiar
very
with that?
comfortable. I am familiar with that, and I'm comfortable that certification could be made today, Your Honor.
Okay,
We
so
don't know what.
that's fine. Stop there. Let me go to the next one. After the certification requirement, 19B is still the land use license requirement or license condition, excuse me. Site plan approval. The applicant shall obtain site plan approval from Dorchester County and certify it to the PSC by filing a statement in the docket that it blah 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 that it has obtained such approval.
Right.
So, and I'm not trying to get into a legal discussion with you. I'm just trying to understand the applicant's position with regard to whether that it acknowledges that there's a license condition that requires site plan approval.
So I do understand that condition exists as well, Your Honor.
Okay.
And I think, and I understand that today's not the forum to resolve the legal question, but I think the challenge that may exist if the county adopts some of these standards is that if the county has the ability to frustrate the CPCN process simply by adopting standards that are inconsistent with approvals that are in the state's interest. I think that's a legal issue that will be decided by other people in a different venue. And I'm probably getting into Mr. Bugelman's territory, not mine, but I think that's the area where I anticipate friction if the county proceeds on the path that they're on.
Okay, but I guess just to finish up this line of questioning, you said the project may not conform to the future acreage limitations imposed by the county. We talked about that. And then also the with regard to the prime agricultural soil component, because the project as currently proposed does not completely avoid, I guess, prime agricultural soil lands.
That's correct.
Okay. Okay. Thank you. Mr. Bugelmans.
Sure, Your Honor.
This was put forth as a uncontested CPCN. I would welcome if you would like to file a post-hearing brief with regard to some of these issues if you want. If you don't want, that's fine too.
I think that's fine, Your Honor. I think what would be useful is if you could tell us, obviously I have a sense based off your questions, the issues that you're interested in, but if you could maybe pose the questions presented in a way that we could just be, perfectly responsive to what you want, that would, I think, be useful for us.
Okay. What I'd like to do is ask witness Rogers some questions, and then I will circle back with that based on what she's able to tell me.
Okay.
Okay. Mr. Tulson.
Yes, am I unmuted, Your Honor?
You are. Are you able to give me an attestation?
I can. I hereby attest that Jenny Rogers, PPRP project manager, is alone. She's in a separate room and she's not in communication with any other individual.
Thank you. Ms. Rogers, can you please raise your right hand? Somebody needs to be muted. Okay. Sorry.
It might be me. My husband is on the phone downstairs. Can you hear that? My house isn't big enough.
I don't hear it right now. So, do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thanks. Do you know if there's a license condition that would prevent construction debris from being left on site?
There is not.
Okay. So, to your knowledge, the only license condition that deals with waste is the decommissioning?
And the spill control, well, if you're going to talk about hazardous materials, the spill control condition, yes. But I agree with Mr. Bauer that I believe that is something that the EPC addresses.
When you say EPC, I'm sorry.
The construction firm.
Oh, okay. Okay. So there are 4 license conditions that refer to the Dorchester County Code.
Mm-hmm.
I see 4K, 19A, 30, and 31. 4K is utility scale solar facilities must meet the lot size, height, planting, and other requirements of Dorchester County Code 155-50 supplementary use regulations. 19 is land use, and prior to the start of construction, New Market Solar shall complete the following requirements, and A is certification of substantial conformity, which I quoted a couple minutes ago. My question to you, and I don't want to have you try to make a legal conclusion or a legal determination, I can talk to Mr. Telson about that. But what I would like to know is, do you know if in referring to the Dorchester County Code, section 155-50, PPRP is referring to a particular version of the county code?
We're referring to the current county code that was in effect when the applicant submitted this application.
And how would I know that?
I suppose it's not clear in the conditions.
Because what I did see in the conditions, because I looked for it, and under condition 1, applicability of conditions, trying to get a sense of an answer to that question, the last sentence says if CPCN position conditions incorporate federal or state laws through paraphrased language, where there is any inconsistency between the paraphrased language and the actual state or federal laws being paraphrased, the applicable federal or state laws shall take precedence. And then again, under 4, applicable laws and regulations, shall comply with all applicable local, state, and federal laws and regulations. And there's no time frame on there. I didn't see anywhere in the license conditions that a time frame was placed on them. That's why my question. So it's your testimony that, well, wait a minute. There was somewhere else. Didn't I read in your testimony that something was revised?
The comprehensive plan?
No, a regulation. I think it was a, let's see if I can try to find it.
I can look too.
I found it.
Okay.
I think, yes. Page 17, footnote 9. MDSPGP-5 was succeeded by MDSPGP-6 on October 1, 2021. New Market Solar was authorized to perform some in-stream work under MDSPGP-5 on April 8, 2020. In general, MDSPGP-5 requirements appear to continue to apply to the project, but reauthorization may be required for some types of activities. So I guess when you say reauthorization, is that based on the new?
For the revised permit.
Okay, but are you saying in that footnote that there would be a revision caused by MDSPGP-5 being succeeded by MDSPGP-6?
I think that the Corps of Engineers would actually have to make that decision.
Okay.
I'm not familiar enough with those permits.
Okay. So do you know that whether PPRP's position is that if there is an amendment to a county code that occurs during its review, that it only looks at the county code that was in effect at the time of the application? Is that what you're telling me?
Yes, that is PPRP's position.
Okay. Okay, that's all I had for you. Thank you.
Thank you.
I'm sorry, Mr. Bugelmans, I forgot that Mr. Bauer referred me, I think, to witness Nowatiki with regard to the waste question. Should we try to complete the record there?
Sure, Your Honor. I think that's
Okay.
appropriate.
So, Ms. Nowatiki, do you have an attestation for her, Mr. Bugelmans?
I do, Your Honor. I hereby attest that the witness is alone in a separate room and not in communication with any other individual.
Thank you. Ms. Nowatiki, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. Were you listening to the questions I had regarding waste and waste disposal during construction?
Yes, Your Honor.
What can you tell me about the applicant's plan with regard to that?
Sure. During construction, we usually have a truck that comes out and takes away all the debris from crates in regards to panels that are brought on site. And after construction, we do a cleanup, and those wastes are either burnt or taken to a waste dump location.
Okay. Thank you. I think that completes the record on that issue. So back to you, Mr. Bugelmans. You, as you know, what's required under the Public Utilities Article, Section 7-207E, is that the Commission give due consideration to the consistency of the application with the comprehensive plan and zoning of each county or municipal corporation where any portion of the generating station is proposed to be located. And I don't believe that 7-207E gives an indication as to the timing of that. So I was offering you the opportunity to submit a post-hearing brief with regard to the timing. Do you need more information from me?
I don't think I need additional information, Your Honor. I do think, I mean, I could answer the question now, which I think is the commission looks at what's in the record when it issues this decision. And what the record reflects now is that the county has not updated its zoning ordinance to be different than what existed at the time when the applicant submitted his application to the commission. So I think it kind of begins and ends there. I don't know. I'm happy to provide whatever legal background or analysis you think would be useful, but I also don't want to create extra papers for other counsel to respond to and that kind of thing. I think it is fairly simple.
Okay. Sorry to make you repeat. Did you say that because no zoning ordinance or other legislation have been enacted yet? Is that why you're basing your...
That's correct, Your Honor. Obviously, with respect to the comp plan, and it's, part of the reason why Mr. Showalter's testimony covers both, the commission has to look at the comp plan that's in effect. I think we're coming up to a point where obviously the new comp plan will be effective. Mr. Showalter discusses the differences between the two, and and that was intentional to be able to provide information on both so it'd be reflected in the record. But I think it's clear that whatever the law is in effect at the time the commission issues this order is what the commission looks at. I think what is also true is in cases where this happened, for instance, the Lagore Bridge case, the commission hasn't looked favorably on changes that were enacted during the middle of a CPCN proceeding. So for instance, in the Lagore case, we had a case where a county completely revised this entire process and ordinance basically in the middle of the case. And the commission did not look favorably on that and ultimately issued a CPCN, notwithstanding the fact that there was some inconsistency that it found. So I don't think it's something that would prevent the commission from issuing an order approving a CPCN. But we have seen that before, and that is how the commission has grappled with that in other cases.
Yeah, no, I agree with you there. This is probably more of a logistics issue to me. Just I actually don't know what happens if the commission needs to consider something and that something is changing pretty much simultaneously with the consideration. In other words, if the zoning amendments were to happen, after the record closes tomorrow, but the order doesn't come out until sometime after that. And maybe that's just something that I have to figure out. But that's probably more of an issue than because I agree with you that this doesn't prevent the commission from making a decision.
Your Honor, can I add something?
Sure.
I'm sorry. I just wanted to help and state that the zoning ordinance for solar was added in 10/18/2011 by bill number 2011-7. So that could be a way to relate that this project must meet this particular ordinance.
So I guess you're correcting Mr. Showalter's testimony, because he had said subject to check. He thought it was 2014. You're saying it's 2011.
That is correct.
Okay.
October 18th, 2011.
Your Honor, I confirmed the same date. I was going to share that with you, so I agree with that.
Okay. I guess based on this discussion, I'm not asking you to file anything. Again, I was just offering the opportunity, and it doesn't sound like you feel as though it's necessary, so I won't add that to the procedural schedule. I just want to make sure I don't
May I provide one additional comment that may help provide some additional context just on timing?
Sure.
The Dorchester County Code has a very clear provision for amendments to the zoning ordinance. And so the process is that amendments have to be initiated by the county council, then referred to the planning commission, which reviews and makes recommendations on those amendments. Their recommendation goes back to the county council, and they have to hold a duly advertised public hearing. Zoning hearings require at least 15 days of advertising. The county council meets twice a month. The planning commission meets once a month. And then under the county charter, legislation doesn't become effective for 60 days after it's adopted by the county council. So the current context is that there is a draft of a portion of potential zoning amendments that's just started to be circulated. I anticipate it's probably 2 or 3 months before the county has a more concrete proposal that might be initiated in the legislative process. And then because of the sequence of planning commission and county council meetings, their zoning text amendments generally take a minimum of 3 to 4 months to complete if they take every action they can in a single meeting and coordinate their advertisements relatively closely. And then they don't become effective until 60 days after they're enacted. So I don't presume to know what the timing of a decision might be, but I suspect there's probably at the least 5 to 7 months before any zoning change might be effective or enacted by the county.
Okay, that's helpful. Thank you. Okay, I just going to make sure I don't have any more questions. Okay, does anyone have any questions based on my questions? Or
I do have one clarifying question for Mr. Showalter, Your Honor.
okay, go ahead.
For questions. Mr. Showalter, could you please turn to page 2-15 in the 1996 county comp plan? Or
yes,
scroll to it on your phone, please.
That I was going to provide that page reference for the prior question. So the question before about the quotations on lines 26 through 35 of page 10 of my testimony, that comes from the first full paragraph on page 2-15 of the county's comprehensive plan.
Okay, that answers both that question and my next question. So I have no further questions.
Okay, I was just going to pull that up so I could make sure I saw where we are.
Just for context, Your Honor, the comprehensive plan in 96 divided the county into different areas where it articulated their plans. And so the areas 1 and 2 were the incorporated towns in areas adjoining. Item 3 was development areas, and item 4 was agricultural areas. The project site is mapped as part of the agricultural areas. And so this paragraph comes from the text of the plan addressing the agricultural areas, which are the areas in which this project is cited.
Okay. Thank you. Is that everything? Does anyone have anything else? Okay. Thank you, everyone, for your participation today. We can go off the record, Doug.
We're off the record, we're off the record, Your Honor. Thank you.
Thank you. Take care, everyone.
Hi, everybody.